And you walk amongst the stars at night. Welcome. I'm John Miller, founding attorney at Rock Solid Law and Title. Thanks for joining our regular monthly webinar. We had a number of people sign up to join us today. And I think people have caught on to the fact that if you sign up, we're going to send you a link so you can watch it later. Attendance is low today, but I promise to teach this subject matter. I think it's really, really important, and I'm going to run through it. If you're watching on the replay, send me a text and let me know, or an email and let me know you did it, and whether this is valuable to you. I hope it is. Why you would attend a webinar like this, because it will save your clients and customers money and cause them to value you as an expert in this subject matter. Most of you know that in addition to real estate, we practice in estate planning and business law, and all those tie together in this quick masterpiece of a lesson. So why do we do real estate? Well, we protect families, and I believe that real estate is the building block of the American dream. Everybody agrees they want to pay the least amount of taxes, and obviously portability is specifically set up for Floridians with respect to their homestead, residents only, and is a way to save taxes throughout their life. I don't know that they'll be thankful to you every year that they get a lower tax bill, but I guarantee if they get a higher tax bill because you didn't tell them about this, they're not going to think well of you, and they are going to not continue to do business with you, candidly. So there's math and taxes involved in this, and we're going to run through it. Best case scenario, you fail to inform your client of portability. They're going to be mad with you. Worst case, they're going to sue you. I know brokers really want you to have a traceable method of advising people about portability. I had clients in the other day that their 3-year window was closing and they needed to get busy. And they said, somebody mentioned something about it, but we didn't know what to do. So what to do? The deadline is March 1st. You have a 3-year time period to get it done. And that clock ticks from January 1 of the year in which the closing occurs. That's right. It doesn't matter what day of the year that the closing occurs. It can be December 31st. It can be sometime in August or June. The clock starts at January 1 of that year. So portability, people, what does it mean? Break it down. Port is to carry or transport something. And ability is the talent or proficiency to do something, the skill to get something done. So portability is the ability to easily carry a tax advantage from one homestead or residence in Florida to another. All right, point number one, it has nothing to do with investment properties, rental properties, commercial properties. It is only applicable to a homestead, and it is only applicable to a homestead sold in Florida and transported to another homestead in Florida. It can't go to North Carolina. It can't go to any other state. It's got to be in Florida. So got it? Homestead to homestead. Where did it come from? We've always valued homestead in Florida. If you're interested in that, I've got webinars on the website about Florida homestead and the 4 different protections it offers. But this particular concept started with the Save Our Homes Act in Florida, which became effective January 1, 1995. And it limited the annual increases in the assessed value of a property with the homestead exemption to 3%, or the change in the consumer price index, whichever is lower. And believe it or not, some years that CPI is lower than 3%. So it's the ability to take some of that benefit to the next home. And then we, Floridians, went even further, and we adopted it in our Constitution in January of 2008. So this is not going away, all right? It only applies to the value, the assessed value of the property, not to the actual taxes themselves. So the calculation is to what value will you pay taxes on? All right. So it's the difference between the assessed value and the market value of homestead property due to the annual increases or limit to the increase on assessed value. So in Florida, we're very much used to, and it's never a straight line, but neither are my hands straight anymore. So, Florida property values, they go up like this. Well, if you apply a 3% rise, it's something like this, right? So the difference in here between the fair market value and the rise in the assessed value is a tax benefit to the taxpayer. In other words, their property is worth the higher level. They're only paying taxes on the lower level. Well, Florida didn't want to cause people to have to stay in the same house just because of the tax benefit. Maybe they're empty nesters. Maybe they're downsizing. Maybe they've made it big. They want a bigger house, and they're moving. And we allow Floridians to carry this tax benefit as many times as they want during their lifetime, obviously, from one Florida residence to the next. Okay. So you have to take I think the fair market value, if it was an arm's length sale, is as good an indication as of real fair market, and then subtract the assessed value, and that little number in between. That number in between is the amount that can be taken to the next house, all of it up to $500,000 on an upsizing. And there's a whole part of it on a downsizing. And there's a calculation we're going to talk about in a minute. So the first year that a home receives a homestead exemption in Florida, the property appraiser assesses it at the just value. You can challenge that. My theory is they set it at the highest number that nobody will challenge, right? So it's usually lower than what we really believe our properties are worth. Now, with that in mind, in the following years, that assessed value cannot go up more than 3%. Okay. So the CPI may come into play, may not come into play, and you just have to look online to see which one of them was applied for every year. But it can never go up more than 3%. And as everyone does, we hope that our values rise. And then family decides, or person, the seller wants to move to a new house, and the Save Our Homes Act allows them to take the tax benefit they had on their old residence or homestead to the new one. All right. So you've got to move it at a time when the homestead exemption on the old home is in any of the 3 tax roll years preceding the year for which the new homestead is established. And that's why I say it begins to count from January 1 of the year in which the closing occurs. All right. Again, if the new homestead is of equal or greater value, the homeowner may port up to $500,000, $500,000, of the cap value of their new homestead. Anything above that, like Florida's like, that's too much, doesn't count. So you get $500,000, that's a pretty good deal. All right. If the homestead is of lesser value than the old homestead, a percentage of the accumulated benefit may be transferred to the new homestead. All right. So the amount is either transferred in its entirety or as a percentage, depending on the value of the new property. Never more than $500,000, right? So downsizing, how do we figure out what percentage? Well, it's a complex calculation. So we hired an app creation service. So you could go to our website, rocksolidlaw.com, go to services, go to real estate, just scroll down just the tiniest bit and you'll see the portability calculator. You only need this calculator. You can do it on an upscale, right? But it's either the amount or $500,000. On a downscale, you can enter the numbers into this, the fair market value, the tax assessed value, and the value of the new home, and it'll run the calculation. It's a decent percentage, but they're not going to give you all of it because you could technically get into a negative tax situation, and that's never, ever going to happen. All right. So if there's a downsize, they're empty nesters, they're going to a smaller house, or for whatever reason, they decide to go to a less expensive home. I guess I said smaller, size doesn't matter. So, you do not have to sell your existing home to qualify for portability. If you own an investment home and decided to move into it, you could port to that other home, or you could port to a new purchase. All right. But you have to abandon your existing homestead and accept homestead at the new property. All right. A Florida homesteader can do this unlimited times. All right. So really, it's not that difficult a concept. And our firm doesn't go and challenge tax values with the tax assessor, but we can refer to other firms that do. But we do provide the portability calculator, and we help educate people that this needs to be done. You, as realtors, I think everybody that signed up today is one, really need to advise your clients of this. So what I have offered in the past, and due to you attending today or watching this on the replay even, write us at questions at Rock Solid Law, and we've created a document you can hand to your client to educate them about portability. What I would suggest is that we co-brand it with you. You send us your PDF. We'll put your logo on there. We'll put our logo on there, and you can hand it to every one of your clients, that's the sellers, so that they understand that they have this tax ability, and tell them if they don't understand to talk to somebody, us or somebody else. All you got to do is get on the website and apply. Now you may have to go and argue that it's more than you should be entitled to more than they're saying you should get on first blush, but you ought to at least get whatever you can, because this tax benefit is going to inure to that Florida homeowner for the rest of their lives, or the time that they own that home. All right. So the other thing I would be happy to do, and I've done with several of the brokerages that we have the privilege of working with, be glad to come teach this thing live. I'll actually go through the math live. I don't do that on the webinars anymore because the calculator really takes care of it. But I don't know. I feel like if we get together, I'll bring an example and run through the math calculation. So really, that's all there is to this subject. It's a quick one, but it's a really important one. And I can tell you, this week, I sat with people who couldn't understand why the title company and the realtors didn't tell them that they had this opportunity to port their tax benefit to their new home. Fortunately, they're still within their 3-year window. So we told them what to do, and they're going to go get that fixed. All right, guys, that's all I've got today. I will be very candid with you. I'm going on vacation tonight, and I have a lot to do. I'm John Miller, founding attorney at Rock Solid Law and Title. We would love the opportunity to close your next listing. And if I can be of help answering any further questions, write me at questions@rocksolidlaw.com. Thank you guys for joining me this morning. I'll see you next time. Bye-bye.